One of my videos, I told you that what I was trying to do was give you reasonable information. So to make an informed decision before you can give informed consent. That's mandatory for every lawyer. I'm not a lawyer, but it's in the rules of professional conduct. Okay, but there's always been an argument with lawyers. No, we're not all public servants. Yes, they are. And every lawyer, no matter what side of the table they're on, must do what's in the public interest and maintain the public trust. And I told you before, the legal system is part of the public trust. Okay, I'm using Illinois right now because I'm in Illinois, but it's the same everywhere. Okay, the rules of professional conduct for Northern District of Illinois. These rules have been numbered of permit ready identification. Okay, where's the part I want to get to? This thing is sticking. Okay, the practice of law, it says right here, committee comment, preamble to the rules of professional conduct. The practice of law is a public trust. Okay, so that means if you look up the public trust doctrine, that means that's part of your trust fund. As we, the people, citizen of the United States. So please, whatever you do, read the public trust doctrine, okay? Because that belongs to you, and your public servants are in charge of taking care of it, okay? So you read and we're going to go over a list of who else is in the public trust. But every lawyer, the whole legal system, it's part of the public trust. And I'm teaching you what they're not doing, but what they're supposed to do. You know how they work the system. I'm just trying to show you how it works. So once we get into the rules of professional conduct, you'll see a lot of things they're supposed to do, they don't. And a lot of things they can't do, they do. Okay, that's depriving you your rights under the color of law. Okay? Deprivation of rights under the color of law. And if you look that up on the internet, you'll see exactly what I'm talking about. But we'll get it. I'm going to do one on that in a little while. Okay, the lawyers are trustees of the system by which citizens resolve disputes among themselves, punish and deter crime and deter or their relative rights, responsibilities towards each other and their government. Lawyers, therefore, are responsible for the character, competence, and integrity of the persons who they assist in joining their profession, for assuring access to the system through availability of competent legal counsel, for maintaining public confidence in the system of justice by acting competently and with loyalty the best interest of their clients, by working to improve that system to meet the challenge of a rapidly changing society, and by defending the integrity of the judicial system against those who corrupt, abuse, or defraud it. To achieve these ends, the practice of law is regulated by following rules. Violation of these rules is grounds for discipline. No set of prohibitions, however, can adequately articulate the positive values or goals sought to be advanced in those prohibitions. This preamble, therefore, seeks to articulate those values in much the same way as did a former canon set forth in the Code of Professional Responsibility. Lawyers seeking to conform their conduct to requirements of these rules, which look to the value described in the preamble, that guides interpreting the difficult issues which may arise under the rules. The policies which underlie various rules may, in certain circumstances, be in some tension with each other. Whatever feasible, the rules themselves seek to resolve such conflicts with clear statements of duty. For example, a lawyer must disclose, even in a breach of client's confidence, the client's intent to commit a crime involving a serious risk of bodily harm. In other words, lawyers must carefully weigh conflicting interests and make decisions at the peril of violating one or more following rules. Lawyers are trained to make such decisions, however, should not shrink shrink from the task. To reach correct ethical decisions, lawyers must be sensitive to duties imposed by these rules, whichever practical, should discuss particularly difficult issues with their peers. Timely, affordable counsel is essential in disputes to be avoided, and when necessary, evolve. Basic rights have little measuring without access to the judicial system, which vindicates some effective access to the system often requires the assistance of counsel. It is the responsibility of those licensed as officers of the court to use their training, experience, and skill to provide services in the public interest. Now, you got to look that up too, the public interest, okay? That's very important. So look that up, because they have to do what's in the public interest to maintain the public trust. And this is part of the public trust, the legal system, all right? Remember, so if you look up the public trust doctrine, you'll understand what I'm getting to eventually, I've been pointing out all along. Okay, skills to provide services in the public interest for which compensation may not be available. It is responsibilities of those who manage law firms to create an environment that is hospitable of uncompensated service by lawyers practicing in that firm. Service in the public statement. This includes I read that. Lawyers' efforts, evidence, lawyers' good character, fitness, practice of law, efforts to the bar as a whole are essential to the bar's maintenance of the professionalism. The absence of these rules, the ABA Model Rule 6.1 regarding pro bono service, therefore, should not be interpreted as limiting to the responsibility of attorney to render uncompensated service in the public interest. Rather, rationale for absence of ABA Model Rule 6.1 is this concept is appropriate for the disciplinary code, because appropriate disciplinary standard regarding pro bono service is difficult, is responsible to articulate. The ABA Model Rule 6.1 itself uses the word should instead of shall, and describing this duty reflects the uncertainty of the ABA on this issue. The quality of the legal profession can no be better than its members. Lawyers must exercise good judgment and candor in supporting applicants for their memberships at the bar. Lawyers must also insist policing of lawyer misconduct. Now, remember, I told you reporting misconduct is mandatory in the Rules of Professional Conduct and the Code of Judicial Conduct, and nobody does that. All you have to do is read the Rules of Professional Conduct and Code of Judicial Conduct, and they're quite easy. They're just as easy to understand as this is what I'm reading to you. Lawyers must also assist in policing of lawyers' misconduct, the vigilance of the bar in preventing and, where required, reporting misconduct can be a form of deterrent to such misconduct and key to maintaining public confidence in the integrity of the profession as a whole and face with the egregious misconduct of a few. So anybody who violates the rules of professional conduct or the Code of Judicial Conduct is what? They're what? The egregious misconduct. That's egregious misconduct, okay? So legal services are not a commodity. Rather, they are a result of efforts, training, judgment, and experience of members of a learned profession. These rules reflect a sensitive task of striking balance between making available useful information regarding the availability and merits of lawyers and the need to protect the public against deceptive or overreaching practices. All communications with clients and potential clients should be consistent with these values. This part right here. I love this part. A lawyer-client relationship is one of trust and confidence. Such confidence should be maintained only if the lawyer acts competently, and that's a rule. They must act competently. It's called competence, Rule 1.1 or something like that. We'll get to that later. The lawyer-client relationship is one of trust and confidence. Such confidence can be maintained only if the lawyer acts competently and zealously pursues a client's interests within bounds of the law. Zealously does not mean mindlessly or unfairly or oppressively. Rather, it is a duty of all lawyers to seek resolution of disputes at the least cost in time, expense, and trauma to all parties in the court. Okay, so that's just a little bit of Oak. I'm just trying to encourage you, to take a look. I'm just using the Illinois version. Okay, but you can find it in any state. And there's a couple other things I want to go over. You say, oh, what can I do if they're breaking the rules? Okay, you Google the rules of professional conduct in whatever state you're in, it'll come up. And if you want to get it, I'm in Illinois, and if I want to get it from Georgia, I'll just put Georgia Rules of Professional Conduct or the Rules of Professional Conduct Georgia, and I'll get Georgia's. But you also want to Google Rules of Professional Conduct Complaint Form. Okay, so then you'll get there, and there'll be a complaint form, and you can print that out, but you look at it, and it'll tell you where to file, and you just put in there all the rules that they filed. Now remember, we'll get into that more detail of that, because there's a lot of stuff you might not get, but you'll get it after I point it out to you. Okay, so I'm going to do one on the rules of professional conduct, and that's part of me giving you reasonable information to make an informed decision. So that way you can actually give, informed consent. Because without knowing what any of this, how could you give reasonable knowledge? And it clearly shows that in the Rules of Professional Conduct. All right, thank you. Have a good day. Good night. God bless. Take care.